Good.
Thank you again, Eleonora, for this kind words of invitation and introduction, and of course also for the invitation to this beautiful PhD seminar. Yeah, I'm happy to be here. We had very exciting discussions in the morning, and I decided to alter my presentation a bit accordingly so it can be even more fruitful for the group and for the discussions. So please forgive me if the animations are not perfect all the time. I will talk now to you about the Due Diligence Act in German business law. As you all know, and as we've discussed earlier this morning, we have a Supply Chain Act in Germany that has entered into force recently. So since 2023, businesses have to stick to the rules that I'm going to present quickly, and I'm going to provide you with some information. So especially if you're doing research on this German Supply Chain Act, you will be happy to hear that there are vast materials of the German federal government, of the respective ministries, and of our supervisory authority online. And I will just quickly and short in a minute provide you with the link. Today I'm going to talk basically and especially about the scope of our Supply Chain Act, about its core obligations, and about enforcement, because I think that enforcement is a very interesting and relevant topic, and this is what we have seen in the morning session as well. We try to give some assessment on the implementation as we have experienced it so far, and of course I'm going to start with a little background. So this is the Act, this is the full official name, the English translation, the Act on Corporate Due Diligence Obligations in Supply Chains. And as you can see, the German name is also very long. So we just call it Lieferkettengesetz, which will translate to Supply Chain Act, or we use the acronym LKSG. And there is already the link for the English and even Spanish version. So as you can see, the German federal government is keen on advertising its act throughout the European Union and maybe even further as a role model. This is where you can find the information on the Supply Chain Act. You also have FAQs that are very useful, I think. And as you can see, here we have this Bundesamt für Wirtschaft und Ausfuhrkontrolle, which I will mention quite often in my presentation, because this is the supervisory authority that is responsible for the implementation and particularly for the enforcement of the Supply Chain Act. And it plays a big role in that respect. It even has taken in some way a lead of interpreting and concretizing the German Supply Chain Act. So this is really an interesting point, because we have an executive part of the government and not a legislative body that is very much involved with interpreting the Supply Chain Act. All right, as regards the background, we have had one famous lawsuit. This was the first lawsuit as regards supply chains or global value chains in Germany. This was a case that arose when a retail company, so a fast fashion sweatshop, you might say, in Pakistan, burned to its ground, and several people died and were injured. And the victims, or the survivors, and their families sued a German company for damages. And the German company is called KIK. It is a textile discounter company, and almost all of the clothes was manufactured in that firm Ali Enterprises in Pakistan. So one very interesting case where all practitioners and academics involved were very interested in the solution of the courts. However, the court did not provide a solution. It didn't even answer the question, but it said the case was just time-barred because the claimants came too late. So the case was not solved, which is, of course, a pity. However, this case has really sparked the debate about global value chains and human rights in Germany. As far as the history of the LKSG is concerned, we have the same background as in all the other national acts on supply chains. Of course, the UN Guiding Principles for Business and Human Rights, mainly also the OECD principles, but mainly the UN Guiding Principles for Business and Human Rights, so Ruggie principles. These guiding principles had to be implemented into German law, and therefore the German government came up with a national action plan. So this national action plan is obviously just an action plan. It is not binding law. And as you can see in the consecuting enterprise surveys, it wasn't really followed. So what the government wanted to do here is they wanted to make sure, just by having these surveys, that enough German companies were following these voluntary guidelines, and thus the government would not have to act. However, the opposite was the case. The studies clearly showed that not many companies were following voluntarily. And so the government had to act because it had put this intention into the coalition agreement and try to come up with some regulation. The first draft was already a leaked draft in 2019. I have left it out here because it quickly, the government quickly, so to speak, did not really align itself with this leaked draft, but came up with another draft of February 2021. And then we had the second one. We always have like first a Referentenentwurf and then a Regierungsentwurf, so we always have two drafts. This is nothing special. And then the LKSG, our Supply Chain Act, was adopted and entered into force later on January 1st, 2023. However, it will have a staggered scope of application, meaning that next year, like in a couple of weeks, 1st January 2024, the scope will be broadened and more companies will fall under the LKSG. I can be quick on the comparative context because we already heard about the Transparency Act in Norway, and we already talked a bit about the other initiatives, though only briefly. But as you can see, we are not the first movers in that respect, but Germany still considers itself to be in the first row. All right. So let us check out the overview of German LKSG and the main characteristics and limitations. As I said, we're going to talk about the scope and about the concept of the supply chain, and both are in a way limited. This also is true with regards to the due diligence duty itself. And then when it comes to enforcement, we have again limitations insofar that Germany relies exclusively on public enforcement, so we have no civil liability either. But this doesn't mean that we don't have a debate on civil liability. This one is ongoing, but at least the Act excludes civil liability. So let us look at the scope now, the scope of application. So this year we started with big corporations or companies that have 3,000 or more employees. And those companies, regardless of their legal form, fall within the scope of the German Supply Chain Act. They also have to have the central administrative, the principal base of business or administrative headquarters or statutory seat in Germany. If they don't, they at least have to have a domestic branch office in Germany. And this will be extended to more companies in January next year, companies that have 1,000 employees or more. So in absolute numbers, this year we started with about 900 companies in Germany falling under the scope, and this number will rise to about 4,000 companies next year. What's interesting, if you compare this with the CSDDD proposal, that high impact sectors are no aspect here, no criteria for the scope, as well as the annual turnover. So this is something that we don't care about. We just look at the numbers and at the connection of the company to Germany. All right. Then let us look at the material scope of application. The Act applies to the supply chain. So what is the supply chain? The supply chain, in the meaning of the Act, refers to all products and services of an enterprise. It includes all steps in Germany and abroad that are necessary to produce the product and provide the services, starting from the extraction of the raw materials to the delivery to the end customer. And this is the definition of the act itself out of section 2, as you can see here. So it is the supply chain, as you can read it here, is very, very wide. However, we have limitations when we come to number 1, 2, and 3, even if they are not directly detectable. So the supply chain includes, firstly, the action of the enterprise in its own business area, then secondly, the action of direct suppliers, and thirdly, the action of indirect suppliers. So this is this 1-tier, 2-tier system that I think you mentioned earlier. So when we read this section, it seems like we really cover everything. But yeah, as we already discussed, that's not true. So when it comes to indirect suppliers, we have many restrictions that are visible later in the Act. With regards to indirect suppliers, the obligations of the Act don't apply. It is just the case if certain requirements are met, but this is very restricted. Okay, but let us continue with the own business area. So as you can see, direct and indirect suppliers is a concept that we could talk about. The direct and indirect suppliers concept has not been implemented into the CSDDD, but I think it's even more important to talk about the own business area. What is the own business area? Because this is what we have been discussing earlier, and this is what I tried to add here into my presentation. What is the own business area? One very important topic is the responsibility in groups here. And in that respect, we have another section of the Act, and the last sentence is what is important here. In affiliated enterprises, the parent company's own business area includes a group company if the parent company exercises a decisive influence on the group company. So as you can see here, the wording of the Act is interesting because it doesn't just say group companies, but affiliated companies. This has something to do with the relation of the Act to the German Stock Corporation Act. And in the Stock Corporation Act, we have a definition of affiliated enterprises in section 15, and we have also a definition of groups. And the LKSG, so the German Supply Chain Act, chooses to use the broader definition of affiliated enterprises for groups. So this is really a term that is very wide and untechnical, you could say. So the companies could be connected in different ways than the traditional group. However, what is decisive here is the decisive influence. And this is the criteria that now everyone is discussing. What is a decisive influence on the group company? Because this is not explained in the Act. And the discussion in the literature goes even so far as to refer to findings of the ECJ in different areas of law, you could say, and we find here opinions that say a decisive influence is only met if we have 100% influence, and not even in theory, but in practice, it has to be really exerted. So the influence has to be there theoretically, and additionally, it has to be really exerted. Only then do we have a decisive influence. But this is the strictest opinion, and we have opinions that are less strict. So let us now look at the due diligence duty. There we have section 3 of the Act, and I think section 3 is probably the most important section of the Act because it explains what due diligence obligations really mean. Enterprises are under an obligation to exercise due regard for the human rights and environment-related due diligence obligations set out in this division. So there are several things important here. Firstly, they have to exercise due regard. That means that the behavior of companies is important and not the success. So if in the end of the day, human rights are violated, this could probably be not a problem under the Act, because the company has to try in a way with best efforts, with due regard, to prevent, detect, prevent, mitigate, and so on and so forth. So we have a strange type of obligations that we actually are not familiar with in German law. This is this kind of, due regard, exercising due regard obligation, not a success. And what do they have to do? Prevent, minimize any risk to human rights or development-related risk, or of ending the violation of human rights related or environmental related obligations. And then we have a bit concretization here, what the due diligence obligations include. And this is something that has very much found its entrance into the CSDDD. So the European concept and the German concept are very much alike in that respect. So I think I don't have to elaborate so much on that, but these are the obligations. Of course, we will look at a few of them a bit more in detail. Yeah. So you can see what I want to emphasize here is the differentiation between direct suppliers and indirect suppliers, which you can see here in number 5 and in number 8. So laying down preventive measures is only important in the own area of business and vis-a-vis direct suppliers, but not vis-a-vis indirect suppliers. And number 8, implementing due diligence obligations with regard to risks at indirect suppliers is only the case if really risks are detected. So if you think, wow, I have here an indirect suppliers and I have now information that my indirect supplier is violating human rights, then I have to go and step into the field of due diligence. But if I don't have information on this, I don't have obligations. So the big problem here is the obligations are not really clearly formulated. We have a problem with the exercising of due regard. We don't know really what companies have to do. And then we have another provision that says that companies have to act in an appropriate way, and we don't know what that is either. But we will come to that in a minute. So as far as human rights and environmental aspects are concerned, we have the same model more or less as the Norwegian Transparency Act, as I understood from this morning. We don't introduce new own German obligations in that respect, but we just refer to international agreements and just take up on these and put them into the Supply Chain Act. And out of these 14 agreements, 11 deal with human rights issues and only 3 with environmental issues. So we have a clear focus on, as you could say, the social aspect of sustainability. All right. The problem is that we have here, and this is the same problem that we have on a European level when we deal with the CSDDD and and all other jurisdictions that use this model, that we have a problem of application when it comes to the international agreements that are now being used in an area of law that is more like private law. And these international agreements were never drafted to act as norms in substantial national private law. So it is not that easy to apply them just like they are. So here's the other section I just mentioned quickly. The appropriate manner of acting in accordance with due diligence obligations is determined according to. So companies must act with their best efforts, and they have to do it in an appropriate manner. And this is the second big problem that we have, because we can't really define what appropriate manner means, although the Act tries to give some clarifications here, but in the end, the obligations still remain pretty unclear. All right. Yeah, so now we come to the very interesting field of enforcement, and there we can start with a very important section of the Act that just sweeps one big discussion off the table. This is Section 3, and it says that a violation of the obligations under this Act does not give rise to any liability under civil law. So if we come back to the KIK case, now I mentioned in the beginning of the presentation, the victims in the KIK case that sued at the LG Dortmund are still not able to claim damages under the LKSG because the Act expressly excludes civil law action. However, the Act also says that any liability under civil law arising independently of this Act remains unaffected. So this sentence was inserted into the Act because the lawmaker obviously knew that there was a big discussion going on, and the lawmaker did not want to interfere or solve this question in one way or another. Yeah? So they particularly said that this Act does not alter the discussion, but doesn't give an own reason for civil liability either. So what do we do instead to enforce these obligations? Because in contrast to the Norwegian Transparency Act, it is not only that we have to report here, we have really obligations to act. How do we enforce them? Therefore, we rely only on public enforcement, and this is why we need a competent authority. So we already have one. It is the Federal Office for Economic Affairs and Export Control. We just use the acronym BAFA, B-A-F-E, and they have to monitor and enforce everything. They take a risk-based approach. We'll come to that in a second. And yeah, they have started their work. They are very busy now, and they have a personal problem because there's not enough staff. Because this office has existed before. We have not created this office just to supervise the LKSG, but it was just staffed a little bit better, and now it has to work and really be really engaged here. This is Thorsten Safarik. This is the head of BAFA. He's not a lawyer. He's a mathematician, I think. And there you see where BAFA is situated. So yeah, not that far away from Berlin, but in the eastern part of Germany where there's not much else, but yeah, especially in this part. But as I also work at a university that's situated in the eastern part of Germany, I can say, we are close to where the LKSG is now enforced. This is why I have it in my presentation usually, because as coming from the University of Halle, we have to show that coming from the east, there's something happening. And you realize that there's still, even if the wall has come down many, many years ago, there's still a separation discussion of East and Western Germany. So we still have issues with it. All right, but we want to talk about enforcement now. And there are some very important and very, very interesting things talking about the enforcement. We have the risk analysis that BAFA has to do. We have a complaint procedure, and they are looking and checking the appropriateness and effectiveness. And therefore, they have issued some documents. So as I said, BAFA is obviously an authority, legal. They are a public authority. They are not a lawmaking body, but still they are issuing guidances for companies that fall within the scope of the Act, in order to interpret the Act and help them. And we have these three guidances. And as you can see, the guidances are on issues of the LKSG that are problematic, like, for example, the appropriateness, because we don't know really what it is. But now we have the guidance of the BAFA saying us what appropriateness means, but they have no democratic legitimacy to really come up with the final solution. But this is basically what they do. And then they have come up with a reporting questionnaire, which I personally find really great. I have a screenshot and I will show you in a minute. But the questionnaire will really help companies to implement the LKSG. So what are the instruments of enforcement? Firstly, of course, reporting. So as in Norway, we have a strong focus on reporting. And therefore, each company has to come up with an annual report on the fulfillment of their due diligence obligations. And they have to submit it to BAFA as the supervising authority, obviously. And this report is autonomous. That means at the moment, the company is not allowed to combine it with the non-financial reporting under the NFRD. But as Jukka already has put emphasis on, this would soon be changed because now we have the CSRD and then we have one report. However, at the moment this year and the next year until the directive is transformed, companies have to come up with two reports, which is a bit of a hassle, of course, but it is the situation. So how to report under the LKSG? We have this one section about reporting, which is basically twofold. In the first paragraph, it is stated that the company has to report for themselves. Not so important for the market, but in the second paragraph, they state that they have to prepare this annual report, which has to be submitted to BAFA. And this report must at least state in a comprehensible manner, and then we have 4 numbers. So these are minimum requirements that companies must not fall behind, but it is also not very precise. So they have to state whether the enterprise has identified any human rights and environmental related risks or violation of human rights and so on. I won't read out everything to you. And fourth, what conclusion it draws. So a bit hard to understand, like imagine you're a CEO and you have to write your report now. This would be problematic. However, we have BAFA, and here's the thing I really like. You can find on their website this, overview, then some guidance on reporting obligations, and there you can find a questionnaire. And this is a nice instrument because now imagine again the CEO has just to sit down and fill out the questions, answer the questions in the questionnaire. And this is a bit like doing your taxes if you do it interview-based with the software. BAFA states that this questionnaire is created in a way that it just mirrors the obligation of the LKSG. So no, nothing more, nothing less. However, if you really try and read through all the questions, and there are many of them, over 50s, and they have sub-questions, then you realize that there are some options where you can insert some additional information voluntarily. And by doing so, I have a feeling that BAFA in a way alters the way the LKSG is put originally. For example, the LKSG does not require companies to communicate with stakeholders. It just doesn't do so. However, the questionnaire has some place for information how you communicate with stakeholders. So we have a bit of possibilities here. Yeah? So I think this is a nice, interesting tool. All right, and then apart from this funny questionnaire, we have of course other and more, and harder, I would say, consequences for companies because the authority BAFA has extensive rights. So after the report, there can be some audits if there are things unclear. And then if things get really delicate, then BAFA even has access rights. So BAFA employees can enter the company site and can look for information. And of course, hand in hand with the access right goes the obligation to provide info and to surrender documents. What is even harder for companies is that they could be excluded from the award of public contracts. So if they really violate obligations of the Supply Chain Act, they could be excluded up to 3 years. And then there is a financial penalty possibility as well. All right. But the financial penalty in that respect is not very high. I mean, 50,000 euro is almost nothing. When you imagine the companies that fall within the scope, this is not much. But we have more. We have administrative fines. This is just a German differentiation between between different kinds of fees. Yeah? So we have the small financial penalty, but then we have administrative fines, and these can be more. These are harder on the company. So the regulatory offense may be punished with a fine of up to 800,000 euros. So this is much more. And in case of a legal person, because we don't have a differentiation, you can, like with any legal form, you can fall within this act. And if you're just one person and you're having a big business, then technically you could fall under the act as well. But in case of a legal person, this will be the general case, or association of persons, with an average annual turnover of more than 400 million euros, a regulatory offense may be punished with an admin fine of up to 2% of the average annual turnover. And this is what hurts. Yeah, this is what is, it is a consequence. So no civil liability, but this is something that companies are really afraid of. All right. So I already come to my assessment. And in the discussion, like in the German discussion of the LKSG, we have some core points of criticism that are broadly discussed. We have more, but I'm trying to concentrate myself here on the most interesting for you. And first one is, of course, scope. Yeah? And I think this is something that we are now discussing with regards to the EU CSDDD. Yeah? There we have also a problem with the scope. For example, if we should include the financial industry or if we should exclude the financial industry. So the German Act doesn't really say or expressly decide the question, but as far as literature says, and as you can interpret the Act, they are included, and also public companies. So but we still have a narrow scope with regards to the number of the employees. So 3,000, 1,000 are a lot of employees to have, so not many. I mean, 900 companies are not much. And then other factors are irrelevant. But we will discuss this, or we are discussing this anyway on a European level. Then, of course, as I mentioned, the lack of concreteness of the obligations is very problematic. So this duty of endeavor, this new type of duty in German law, has to be molded and developed by courts, because we don't have any body of literature that really puts this into place. Then I think what is probably one of the biggest problems that we can probably answer now in a different way, because this is our approach, is the regulation technique that refers to international standards and then puts them into substantial law. So this is, the regulation technique leads to problems, but this is our state-of-the-art solution now. And I have talked to many people now and I haven't come up with a better idea. But yeah, maybe we can discuss this in a minute. Then what I find problematic, this is not that much discussed in German literature, or not seen as problematic, not that problematic, is the clear focus on human rights. Environmental aspects play really a small role. I mean, we have these 14 international treaties that are referred to, and only 3 are of environmental nature, but these 3 are of environmental nature as regards, for example, heavy metals and the influence of the environment. So like the big problems, or many of the big problems, are not addressed. Climate change is not addressed, and many of the other problems related, for example, to the planetary boundaries of Johann Rockström and his colleagues are not addressed. So it's not really a driving force for ecological sustainability. Yeah, then we have this public enforcement that does not provide victims of human rights violations or environmental violations with claims for damages against companies. This could, of course, be changed if Article 25 of the CSDD will stay in the directive, which is doubtful. But there we have a provision that may lead to civil claims or claims for damages. And so the discussion is still pretty much ongoing, because we have the EU directive on the horizon. But I can't present you today with the latest court cases about the LKSG, because we don't have any by now, but I'm sure that it will come, they will come soon. And I hope that this helps a bit, and I'm happy to discuss anything related to the topic with you now. I think the literature has already been, we have already been provided with the literature, and this was already it, and I think we have much time left. I was rather quick. Thank you so much for your attention.